Okay, good morning, dear friends of ACTA. Welcome to this session on the EU copyright reform. This is a long-lasting subject matter, which is actually being closely followed by the ACTA Copyright Committee, most especially on the proposal of the directive on the digital single market. And we prepared a position paper on these, as well on other directives within this copyright reform, for instance, in the cross-border portability and also in the cable and satellite directive. So ACTA is closely following this reform, very interesting, but very complex, I should say, also because there's a lot of interest in balance. We basically wanted to hear the perspectives from the European Parliament on these. Actually, the directive will be voted on the 20th of June. Also, the perspective from industry and finally academia. So we are very pleased to have here three experts in the field from these fields of intervention. And the first one will be Anne-Catherine Lorraine from the European Parliament. The second one, Tobias McKinney from Google. And lastly, Eleonora Rossati from the academia. So we should start with Anne-Catherine Lorraine. Anne-Catherine is a lawyer and researcher in copyright and ICT laws, and since 2015, she is policy advisor in the Committee for Legal Affairs in the European Parliament, representing the Greens AFA political group. So we are looking forward to hear from you, Anne-Catherine, and from the political side and European Parliament. The floor is yours.
Thank you very much. Sorry, I was supposed to switch it. Is it on? Ah, yes, it is. Thank you. Good morning, everyone. Thank you very much for the invitation. I'm very happy to be here, very happy to be in Athens. So the European copyright reform, as beautiful as Aphrodite, well, it's a bit too early to tell, since we are actually in the middle of finalizing it. Well, we're in the middle of the legislative process. But what we can say is that it has been very desirable since a while. We were awaiting the reform proposed by the Commission, and many things are highly desired by many interests interested to copyright. But the other question is whether it's going to be enjoyable tomorrow, and given the shape that it's taking at the moment, and we have to wait for a while to know exactly which shape it will have, we can already have some doubts that everybody will enjoy it. But first of all, to come back a bit on the context of this legislative reform, you remember that we had the InfoSoc directive adopted in 2001, directive on copyright in the information society. At the time, we were preferring this vocabulary, talking about the information society, which curiously enough, we don't really use anymore. Now we're more talking about the digital single market as a kind of general context of the copyright reform. So it's already a while that we had this directive, this general directive on copyright. There was, of course, a lot of other instruments on specific aspects of copyright that were adopted actually before, on the rental rights, on cable and satellite broadcasting, and other directives. But this one was specifically targeting the digital environment. So it's obvious that since 2001, there has been a high need to further adapt copyright to the evolution of the digital society. In 2015, a report was adopted by the European Parliament. It was not a legislative report as such. It was the so-called INI report, or own initiative report, the aim of which was to give indications to the Commission as to the reform that was announced. So in view of the future reform, there were like tracks of reflections given to the Commission. And the drafter of this report was Julia Reda, the only member of the Pirate Party in the European Parliament, who is actually also a member of the Greens. And I was at the time her parliamentary assistant, so I worked a lot on her report. We were quite happy about this report, although we had to compromise a lot, and there were a few things that were not adopted at the end of the day. But still, the Commission then proposed the Directive on Copyright in the Digital Single Market in 2016 in a kind of package, because at the same time, they also proposed a regulation on online broadcasting, on licensing rules pertaining to online broadcasting. And the trilogue is still going on. I will come back on the word trilogue, don't worry. And now it's up to the Parliament to react to the Commission's proposal, and we are currently working on finalizing the report. It's actually just finalized. I will come back on that later, but we had very large shadow meetings earlier this week, and we're going to vote on it next week. And this report is going to be a legislative report, part of the co-decision procedure. So it's a very official legislative procedure, and Parliament's report has to be seriously taken into account. So in this current legislature in the European Parliament, we have 8 main political groups, and each time you have a dossier and you have to allocate a dossier like in a co-decision process, like it's the case for the Copyright Directive. You have to allocate the dossier to a so-called rapporteur who is going to be in charge of the Parliament report. And for this one, it's the main political group, without much surprise, the EPP group, considered as more the center-right political group in the European Parliament, who is in charge of the report. The rapporteur is Axel Voss from Germany. And the principle is at the same time to appoint so-called shadow rapporteurs, so that other political groups are also represented in the negotiations on the Parliament's text. So for my political group, the Greens, it's Julia Reda, who is the shadow rapporteur, and my job is mainly to draft amendments with my shadow and to take part in the negotiations on compromise amendments, and then to do the follow-up on this dossier and on other dossiers, because I'm also working on other files in the jury committee. The jury committee is the Committee for Legal Affairs in the European Parliament. The jury committee has always full competence on intellectual property law, so on copyright law, and in the Parliament, you also have other committees in charge of drafting opinions, which have to be taken into account by the lead committee, by jury. And IMCO, it's the Committee on the Internal Market and Consumer Affairs. They are usually in charge of many dossiers pertaining to the digital single market. And we obtained that they have shared competence on Article 13. I will come back on that. But their opinion is very important, and the rules of procedure of the Parliament oblige the jury committee to take due account of the IMCO opinion on this particular article. But of course, you have other committees who also drafted opinions, like the Libe Committee on Civil Liberties, Cult Committee on Cultural Affairs, and ITRE Industry Committee. So lawmaking, that's a lot of time and politics, of course, but you can see the Parliament calendar. So when we meet in so-called shadow meetings, when we discuss about compromise amendments among all political groups, we cannot meet all the time. So the process is very long. You can see that you have some green weeks. Green weeks is that nobody is around or no members of the parliament are around. They are in Germany, in France, in their own constituencies. So staff will stay in Brussels to work, so we can still discuss among ourselves, but there are no official meetings, so the work cannot really advance. And you have turquoise week. This is more a committee meeting week, so you can have meetings organized during that week. And you have red weeks, corresponding to plenary session weeks taking place in Strasbourg. So this week was actually a Strasbourg week, and we had a very last shadow meeting on the copyright directive on Monday night until quite late to finalize the compromises. But in total, we had like 15 shadow meetings and a lot of meetings more unofficial, so to speak. But the whole process takes time. We started the discussion at Parliament level in November last year, if I'm correct. And the compromise discussion also takes time because, as you can see, we have almost 1,000 amendments on the directive. And you can also notice that the draft report, the rapporteur is Mrs. Teresa Comodini-Cachia, from Malta, who was the original rapporteur, but she had to leave to Malta. She resigned from the European Parliament, so the report was taken over from another member of her group, of the EPP group, so it was given to Mr. Voss. But the original report the draft report tabled by the Parliament was actually drafted by Mrs. Comodini. So it was difficult for Mr. Voss to take over on that, and also for us to know exactly on which basis we could discuss. So there was a lot of negotiations around that. And the art of compromise is something enjoyable and difficult. People are happy, some others are not. But this is something not only at the Parliament level, but also at the Council level or the Commission level, of course. So in Brussels, we don't have gods. So even if maybe some members of the Parliament maybe think there can be sometimes, but for the anecdote, this building of the European Parliament in Brussels is called the Caprice des Dieux, God's whim, because I think it has the shape of a famous cheese in France called the Caprice des Dieux. So you are trademark lawyers, maybe you're aware of that. So we don't have gods in Brussels, but we do have member states who are actually one of the most powerful bodies in the legislative process. They shouldn't be, by principle, because they are not legislative actors per se at European level. They are part of the European Council as government, and of course they help to shape the position of the Council. And this is actually part of this trilogue process I was briefly referring to a bit earlier. You have the European Commission having the initiative of the directive, having the legislative initiative. Then the European Parliament is even actually more involved since the Lisbon Treaty. And of course, the third part of the triangle is the European Council. And the European Council, actually, they have reached their common approach, common position on the directive on the 25th of May, which put some pressure on the Parliament and on the rapporteur to come up quite swiftly with the Parliament position. And the compromises reached among the national governments within the European Council in so-called COREPER meetings, Comité des représentants permanents. We have to take these compromises into account because they help us assess how far we can go in the negotiations that are going to take place and whether strategically it's better to go in that direction or in another to present the Parliament report to the Council when we're going to start the negotiations. But of course, it's more up to the rapporteur to do that, not to the shadow rapporteurs. So copyright is a battlefield in a way, it's true. There's a lot of interests, passions taking place. a lot of lobbyists coming to Brussels, asking to meet members and even staff people. And it's very difficult in that context to reach a balance of interests. So we don't know how Aphrodite will look like, but we can already see that there's a lot of forces trying to influence how it's going to look like. And these forces are focusing, and we are also focusing on two main provisions of the directive, namely Article 11 and Article 13. I'm not going to enter into the details. I think that Tobias and Eleonora are going to talk about that. But Article 11 is creating a new ancillary copyright for press publishers. It's very contentious. And for my political group, if it's adopted, it's a red line. We're really against that. I'm happy to discuss about that if you want later. And Article 13, it's about the so-called value gap, how to strike the right balance when you have creators, authors and performers not having a fair share when their works are distributed on the internet. So it's true that there's a problem, but the question is how to solve it. And the way the Commission and the Parliament, I'm afraid so, is going to propose a solution is not satisfactory at all. So when you look at this stage, at the finalized compromise amendments, it's like being on, at the Parliament level, I mean, but even at the Council level, it's also the same thing. It's a bit like being on an archaeological site when you see all the layers of text, of amendments, of changes, of edits, original proposal, and then we have, for instance, 8 versions on Article 13, which is a lot. And at the end, we end up with this final compromise amendments on Article 13. This is only the compromise amendment on the very Article 13 itself, but it's a part of a package. You have a lot of recitals, and you also have an additional article, an Article 2, aiming to define the online platforms being covered by Article 13, because Article 13, the problem is that it has a very broad scope targeting all online platforms, so there's a need to restrict the scope. But we're not satisfied with that, so we're not going to vote in favor of this final compromise, my group and also other political groups. Because the problem of Article 13 is that the version that we have on the table at the moment in the Parliament, all platforms are performing an act of communication to the public. Thus, they are obliged to obtain a license from the right holders, and if they don't, they are liable. They escape the safe harbor clause in the e-commerce directive in Article 14. Although, in the article, you have a last paragraph saying, oh, by the way, there is no internet filtering. There shouldn't be general monitoring. But we consulted the legal service of the European Parliament to know exactly how to interpret that. The problem is that when you refer to Article 15 of the e-commerce directive, it's intertwined, really it's very closely connected to Article 14. The one cannot go without the other. So if you say that the platform is escaping Article 14, then there's no use to talk about Article 15. So the reference to no internet filtering is actually a fake reference. It's, they claim that it's supposed to reassure citizens that there won't be any general monitoring of their communications. But Article 15 cannot apply in this instance. So we will have to come back on that at trialogue level to really coin down a draft that works, legally speaking. What we have to keep in mind in lawmaking, there are 3 cornerstones. I mean, you have to have legal certainty. All the parties being interested, they have to be sure that things can work in practice, that there's a certain level of practicability given what already exists. You have the e-commerce directive being there since more than a decade. If you change everything, it's going to be a mess. It's also going to be very interesting for lawyers. There will be a lot of litigation. But is it really for the best? I'm not sure about that. Then the second thing is proportionality. We have to find the right solution to a problem. And we acknowledge the problem. It's true, there is a problem. You can call it a value gap, you can call it something else. But it's true that there is not a fair, a right transfer of value between the parties, between the weaker party to the contract and the mighty party. But the solution should be more concentrating on giving the weaker party a genuine bargaining power to negotiate with the biggest ones, not to change the way the internet is working. And the other very important thing is that you have to respect the legal acquis. I was referring to the e-commerce directive, but you also have other things, of course, and the fundamental rights, which the European Court of Justice is regularly reminding to everybody and which the legislator has to take into account. Court decisions should not necessarily entirely guide the legislator, but still, the judges, they know how to implement the law, and you have to look at what they're saying. In many case law decisions, many of them, the court said that you cannot have a specific monitoring of the internet. If you want to go after terrorist content, child pornography, or copyright content, it cannot go without a certain amount of general monitoring. So it's a very sensitive issue. This being said, we are happy with a few things in the copyright directive. For instance, it's the first time that the Commission is addressing the text and data mining issue in Article 3, and we've reached a compromise with the rapporteur that is very satisfactory, so we're going to vote in favor of that compromise. There's another very interesting article, Article 4, the copyright exception for illustration in teaching, that gives a lot of, the solutions to adapt to the digital environment are good. And you also have Article 5 about the copyright exception for the preservation of cultural heritage made by cultural heritage institutions. And we managed to have a reference to public domain works so that they stay in the public domain. When you have digitization of cultural heritage that is already in the public domain, you should ensure that some private entities taking part to the digitization process do not add layers of private rights. And this can be done in many ways. So we have to ensure that this principle should be respected. Then it's up to the practice to see how they can achieve that. But this is a very important principle that my group, that we've been pushing a lot, and we obtained it. So the next steps. We're going to vote on the jury report next Wednesday. We haven't received the draft voting list so far. We should receive it today. The voting list is going to be very long. We have 1 hour scheduled to vote on the directive on Wednesday morning. We are going to table alternative compromises because political groups who don't agree with the rapporteur are also allowed to table other versions of compromise amendments with other political groups, which we are doing on Article 11, on Article 13, and on another article on remuneration of authors and performers. And our alternative compromise on Article 11 is actually a version adopted by the Estonian presidency of the Council a few months ago. And that was also proposed in the draft report of Mrs. Comodini, which consists not in creating a new exclusive right, but in installing a presumption of right ownership that can help press publishers to claim for their rights in court, for instance. Once we have adopted the report, In principle, we're going to vote on a so-called mandate to start the trilogue negotiations. Depending on the result of the vote, we might want to challenge this mandate to go to trilogue, to say, hold on, we don't agree with starting the negotiations already with the Council, and we'd like the Parliament to work on that again and to table amendments. So this is possible, but if the mandate is confirmed in plenary, it will be done at the widest level of the Parliament. If it's not challenged, then the trilogue should start right away. But we don't know when it's going to start. The Austrian presidency are going to start in July. For the moment, it's still the Bulgarian presidency. The legislature of the Parliament is going to end very soon. Members are already starting campaigning for the elections taking place next year. So we don't know how things are going to evolve. It might be possible that the trilogue will last until the next legislature starts. But it might also be possible that some members of the Parliament won't be there anymore, so that there could be another team of members being in charge of negotiating. This is a possibility. Or everybody wants, and we also want to finalize things quite swiftly. We finalize things before March or April 2018, but it will be very tough because it's a long directive. There's a lot of issues and contentious issues. So we hope that Europa Goddess will help us. This is actually the statue in Strasbourg of Europa Goddess. Bearing in mind that the purpose of the Copyright Directive is to better harmonize copyright law, because it's actually one of the areas of law that is less harmonized in Europe. So this should be the objective. The second objective is, of course, to properly adapt copyright law to the evolution of the digital world, taking into account the balance of interests again, and while respecting the legal acquis and fundamental rights, as I was saying earlier. So please wish us good luck for next week for the vote. Thank you very much.
Thank you very much, Anne-Catherine, for this very comprehensive presentation, notably on this complex process of lawmaking and balancing all the interests at stake. And let's face it, as you have said correctly, copyright is the less harmonized IP right in Europe. And the Court of Justice has been very, very decisive on the definition of some controversial issues and legal issues. But of course, we cannot rely only in the Court of Justice to define the content of copyright law. That's why we need a further harmonization, and in this regard, the European Commission and the European Parliament have been decisive for this clarification. We will come back to some questions regarding the trilogue intervention, and I feel that the trilogue discussions are a little bit a secrecy, because the relevant stakeholders don't have access to that discussions. But we come back later to this point if you agree. Now it's time to hear the industry and Tobias McKinney, Senior European Policy Manager at Google. Tobias graduated in law and he's English, but actually works in Brussels, but lives in France, so it's a good combination, a good international combination. Let's hear Tobias from the industry point of view, and let me say that Google changed my life, and Google changed all our lives. So we are very interesting to know your position.
Good morning. That's a very daunting introduction. I'm very grateful for the invitation to speak here today before such a distinguished audience. I wasn't planning to change your life today. But anyway, I have a few slides, but very, very rough. Nothing compared to the beautiful slides that Anne-Catherine provided to sort of go through the metaphor. I'm based in the Brussels team, as you said, in Google, and I work on IP issues, and right now I'm very much focused on the copyright directive because it just happens that it's going to be voted on next week in the European Parliament, as Anne-Catherine said. To sort of briefly go with the metaphor of this conference, a bit tongue-in-cheek, but I might suggest one of the gods that we could maybe affiliate or give paternity with the copyright debate would be Dionysus. Interesting character, I guess. He covers wine, given the picture here, but he's also covering theater and I think madness, which are definitely an interesting take on the way we're doing things at the moment. And then the Socrates paradox, which has been expressed in many ways, but which is I know one thing and that's I know nothing. So first, that's going to be my defense when you ask me questions about the copyright directive. Two, it's an eminently reasonable defense when you look at the copyright directive. Now we're done with the nice slides and we're going with the nitty-gritty ones. Who's read in this room the council mandate? All right, okay, congratulations. If there are any questions from the audience, I'll direct some back to you. Okay, so it's worth spending a little time on where the council stands on this, since I think it could cover the parliament, so that we can have a bit of an understanding of the industry position. The council, I'm focusing on the council because there are many iterations of the copyright directive in various amendments, shapes and forms, and so you could get motion sickness just by looking at the different versions. The advantage of the council one is that it was adopted formally by the council at the end of May, so it's now the second stable text in the policy environment in Brussels after the Commission proposal, and provides a good point of reference. On the process, it's worth noting a few things. For the geeks out there on EU procedure, it was adopted by the Bulgarian presidency as a Coreper mandate for negotiations in the trilogue, which means it's not a general approach which would have required the approval of ministers. It was adopted after 3 Corepers. These are meetings of ambassadors, European ambassadors, who cover a variety of issues. You should look at the agenda of a Coreper. It's got anything from youth funding to copyright on the same morning. So these are very high-level diplomats who cover a lot of issues. 3 Corepers is quite a high number, so it tells you this was controversial and there was a lot of pressure to get this adopted quite soon. And it was also adopted on the basis of a text that reportedly were circulated to the delegations, the member states, depending on reports, like the day before or on the morning of the last Coreper discussion. The final point about the process is the presidency also decided to stop having what's called the copyright working party meetings. So the council process works with experts, first and foremost, who are sent by national governments, travel to Brussels and discuss together all the articles of the copyright directive, and at some point people felt this wasn't working, so they just said, well, we won't have the meeting anymore and we will leave this to ambassadors and the attaches who are their diplomats in Brussels. So I don't want to establish a causal link, but what I'm getting at here is that it has been quite a difficult process by council standards, quite a polarizing one. And perhaps that explains why the text can yield many sort of Socratic paradoxes of what on earth does this mean and what is this about. There are legions of things that are unclear in this text. Perhaps good news if you litigators are in the legal business, because if it gets adopted as it is, there will be many questions at the transposition stage, and you can be confident there will be a lot of litigation around the uncertainties in this text. The main controversial issues, I think Anne-Catherine went over them very briefly. Article 3, text and data mining, has been problematic in the council. Article 11, the publisher rights, and Article 13, which covers user uploads. Article 13's got many names, not all of them polite, so I won't mention all of them. But these tend to be the 3 difficult issues at the moment, both in council and in parliament. So today I'll probably just go over Article 11 and 13. Again, we have to sort of choose because this directive covers a lot of ground. There are a lot of important topics, but from an industry and Google perspective, both of these are particularly important. Sadly, there are a lot of other things that are important in this copyright directive. It's just that there isn't enough time or bandwidth, as Americans would say, to sort of cover all these issues in depth. So Article 11, the publisher right, what's the premise and what's the history? So the premise, at least in the Commission impact assessment on this, is that publishers, news publishers, namely the press and printed materials, are having a difficult time maintaining their business model in the digital transition, which seems a reasonable assumption, but then the difficulty is sort of linking that to copyright. And so this becomes expressed as publishers have difficulty licensing, negotiating agreements in the online world and on the internet. They have difficulties licensing their rights, and they have difficulties enforcing their rights. There was very little hard evidence of the scale and magnitude of these problems, except for, I think, for one reference to court proceedings, and forgive me, I don't remember which ones, where a publisher, I think, pointed out that in order to prove chain of title for his publication, he had to bring an astounding number of contracts before the court. That's the premise. So there are two things I'd like to flag in relation to the premise and perhaps flaws from the beginning. What's the relationship between this situation and between copyright? So what's the relationship between the difficulties of building a press product in the digital age and of building a business model in a digital age? Now let me pause and say at Google, we definitely understand that the transition is difficult, that it is challenging, and that we have to work with publishers to find what's going to be that business model and that product. We just don't think copyright law is a good way of getting us there. Why not? Well, there's no real link between sort of copyright and the change that's happening in the way people consume news and the way people produce it. There's no real causal link. At a very, very high level, the problem with a press product, I could venture, is that it's being unbundled. I don't think any of us today will go and buy a mainstream newspaper when we're looking at the obituaries section, or when we're looking to buy a second-hand car, or when we're looking to buy a house, or when we're looking to find out what's happening in our neighborhood that day or that week. All these services, which were paid ad-funded services, have moved to other platforms, and the product itself, the newspaper, has been disaggregated. So how can copyright solve that issue, or how does that translate into a licensing and enforcing issue, is very hard to figure out. Second sort of questioning on the premise is that publishers are already in control, so there's a fundamental issue with the publisher right, is that insofar as Google is concerned, for example, Google News, publishers are in Google News because they consent to being in Google News. So they indicate that they want to be indexed by Google News, and they say how they want to be indexed, whether they want headlines only, whether they want certain articles only, whether they want photographs to be indexed, and so forth. So if you give somebody an exclusive right, which is a right to say yes or no, we're back to square one, because he's just going to have he's going to be in the same position. We already consider that a publisher has a copyright from his journalists, and so what's the additional copyright element going to bring here? Second, on the history of Article 11, most of you might be familiar with some of it. It started in Germany, 2013, the LSR. I can't pronounce German, I'm sorry, so Q&A, if somebody wants to spell out the full name, that's fine. I will spare you the ordeal. That's led to a lot of litigation currently before the Court of Justice, and it hasn't produced any real results. It's basically a neighboring right which sort of stretches to digital uses by news aggregators and sort of use of small extracts of text. So there's a lot of discussion on how long does the extract of text have to be. In Germany, that was in Germany. In Spain, they tried to introduce the Canon ID, and that's got all the Google tags, all the link tags, which is a different model. That's a remunerated exception. So it says if you have a small snippet used by news aggregators shall be free, provided that you pay compensation by a collecting society. Likewise, that hasn't yielded any significant benefits for publishers. Some of them are slightly offended that they've lost control of their snippets, and in response to this law, Google announced and went through with shutting down Google News in Spain. And then we have the European Commission proposal, which was adopted now almost 2 years ago, and which is slightly different from those ones, and that they attempted to do a more classic neighboring right. So a full publisher right that doesn't really mention snippets, but just says you publishers are going to have a reproduction right and a making available right in addition to what you get from your journalists. The one thing to flag is that these rights were digital only, so that was the main difference between the publisher right in the Commission proposal and a classic neighboring right. Think of broadcaster rights, for instance. Now fast forward a year and a half, and where we landed in the Council text compared to the European Commission text, there's a number of significant departures from the Commission. One, I think, were to be expected. In discussions about copyright, when they reach the political level, you always know that there's going to be a discussion on the term of protection because that's easy to understand. I want 50, I want 1, okay, let's go for 3, that's a good compromise. So it's just a way of bargaining that policymakers can understand. So the term of protection for the Commission was 20 years. It's been reduced to 1, I think. And I think some sort of slight excesses of the Commission proposal, like their proposal granted retroactive protection, incredibly, meaning that publications from the past would have gotten retroactively the new publisher right. That's been deleted by the Council. On the other side, the Council has also had a lot of controversial discussions on what to do with the right. One of them was whether to have a presumption of transfer of rights on the basis that if what you're trying to do is facilitate enforcement and proving chain of title, then you might as well have a provision in the law that says that publishers are presumed to represent the rights of the journalists for the purposes of asserting those rights before the courts or third parties in license discussions. That presumption was actually tabled by a number of member states and was rejected. It couldn't find a majority. So then we moved to a discussion on what should be the form of the neighboring right and how far should it protect things like snippets or small extracts of text or insubstantial parts. There's lots of different language around that, but basically the essence of it was how far do we go into targeting, into creating something new that really targets the use of smaller extracts of text. And here you had two groups of countries. You sort of had Benelux and Nordics and some Eastern European countries who said, over my dead body, I do not want something that protects snippets. If you give a publisher right, that's the furthest I will go, and you will have to make sure that that right mirrors exactly the existing scope of copyright, which is a bit odd for a neighboring right, admittedly, if you're a legal mind. But the idea was snippets shall only be protected if they're original in that case, a little bit like a reference to the InfoPac ruling. And then you have another group of countries for whom this was unacceptable and who said, no, we must protect snippets. And we must make sure that the smallest extracts of text are also covered by this right. And so what we landed on is an option in the Council, which is member states will create a publisher right and they will have the option of either protecting snippets that are original or protecting snippets that reflect the investment of a publisher, hold it, or both. So how the both is going to work, I'm not quite sure, but I think that's still an option. How am I doing so far in the Council text? Okay. So the concept of the publisher right has been really criticized from the academic perspective and by eminent academics. The latest was a letter, I think in May, from 200 academics, including the likes of Sir Robin Jacob in the UK and so forth. So I'm not going to try and attempt to replicate what they're saying. I just want to point out two things and two issues from an industry perspective, since this is my brief today. The first one is paradox. The creation of this right in the Council is going to lead to fragmentation because we're going to have first, the creation of a territorial right, so there's nothing about sort of EU-wide versus national-wide licensing. And second, we're going to have divergences, like there's expressly an option for member states to create different forms of neighbouring rights in each and every member state. The second issue, I think, for us and for a lot of companies working in the digital space is that it's practically based on any definition, but especially on the current one, impossible to figure out what is a news publication online, right? It's not limited to print. It's not even limited to news because magazine publishers want it to be covered, so entertainment is also something that gets neighboring right. So it seems like, yeah, okay, it should have a journalistic nature and should be updated regularly. Now, if you're working at scale, like a news aggregator, like a search engine, how are you going to figure out, like, what is a news publication or not on the scale of the internet is going to be impossible or very, very difficult. And second, it's also going to be difficult to understand, like, when something is published, by whom, who owns the publisher right, if something shows up in a publication but was published elsewhere first, what happens to the rights in that, etc. So there are a lot of very practical questions as to how on earth these things will work, which have never been answered. Now moving on to the other beast, which is Article 13, and that one is very, very broad in what it's doing. I'll try and follow the same approach. Very briefly, the premise of Article 13, and that has done, I think, a lot of harm to the understanding of Article 13. The premise of the Article 13 discussion is a so-called value gap. The idea of the value gap is that services like YouTube, which belongs to Google, are not paying music right holders enough when compared to paid streaming music services, i.e. such as Spotify, and that this is caused by a loophole in the law, the e-commerce directive. So why was this framing sort of problematic? Because policymakers have tended to view Article 13 exclusively as a discussion about YouTube and music right holders. And we should all be aware by now that Article 13 is about far more than YouTube in terms of the breadth and scope of the article. To take a minute on the value gap argument, well, first YouTube paid, I think, $2 billion to music right holders only in 2016, and that sort of rose in 2017, but we don't have a final number yet for that year. So there is money being paid. But let's assume for a minute, for the sake of argument, that we can compare apple and oranges and compare a closed streaming music platform that is paid for versus an ad-funded open video sharing platform, and look at some of the issues here. The first point we'd like to make is, as YouTube, we license music rights from collecting societies and from major and independent labels. When these licenses do not yield an agreement, as was the case in Germany for a long time with GEMA, the collecting society there, we had a blip in Finland with Teosto last year. We use what's called our Content ID technology to remove right holder content from the platform. So in other words, right holders and their content, whether it's theirs or uploaded by users, is something that only shows up on YouTube because right holders sort of agree to it. At least for the music sector, that is true. So that's one element in the comparison, which is we're actually negotiating licenses with right holders on the basis that if we can't agree, we have to remove the content, and this is what we do under the current legal framework. Another point to make perhaps is that it doesn't really make sense to compare value generated per user or even per minute of music streaming. And that will be something that most entertainment law people will sort of be familiar with. The music industry, the film industry is rife with marketing strategies which basically operate price discrimination. It's classical welfare economics. When somebody buys a ticket to go to the movies, or when he watches the movie on free-to-air TV 5 years down the road, you're actually not generating the same amount of money per consumer. That's the nature of marketing and price discrimination in the economic sense, that you're going to have different pricing models. And so YouTube is now moving to a paid model, but as a free service cannot sort of have the same value generation as a paid-for service. These are different business models. Anyway, on the back of that premise, we reached the council, and the council construction, very briefly and incredibly, does three things. One, it states, and it has a definition which maybe Eleanor can elaborate on more, because I find it baffling, but basically user upload platforms. Platforms where users upload content are covered by Article 13. So you've had people like GitHub, who hosts uploads of code share. You've had people like Vivino, which is a wine review thing where people upload photos of wine. All these services are like coming out and say, hey, what have we done? Why are we in the scope of Article 13? So once you're in the scope of Article 13, you're basically communicating to the public yourself when a user uploads to your platform. The criteria here is that you give access to content. Nobody, to my knowledge, has given a definition or an understanding of what giving access to content means, but that's what's in there. So if your users are uploading content, you are liable yourself for any copyright infringement in their upload. And second, you can't rely on the Article 14 Safe Harbor of the E-Commerce Directive anymore if you are communicating to the public in that way when your user is uploading content. So at some point, some delegations, including a German delegation in writing, said, well, we've just created an unlimited liability regime here. Subtext like these platforms are going to die if we leave such a legal regime, and some of them are socially valuable, so what do we do next? And then came a discussion on mitigation measures, which are the measures you have to comply with if you want to escape the so-called unlimited liability regime. And these would be first notice and takedown in some form. It's not clear, but that sort of says you should remove content when you notify it. And then it adds two things. One, you should do notice and stay down. So when you're flagged a piece of content, you should also make sure it's not re-uploaded. And three, you should have best efforts to implement some sort of filtering technology. They don't use the word filtering technology in the council, but it's pretty clear from the text that this is what it is, and from the recitals too. The text doesn't make any sense otherwise. So that's the broad structure of this text. I now have 2 minutes. I'll see if I can bargain an extra minute. Thank you. 2 minutes to give the industry perspective and some of the issues on this Article 13. One, scope vertical. Is there a vertical scope issue with Article 13? We've been talking about platforms all the way, but given that actually in the strict legal language is that if you are storing and giving access to content uploaded by users, you are pretty much communicating to the public. I'm simplifying, but nowhere in these concepts do we know at what point you have to be in the chain between a transmission from a right holder to a user to fall under the scope of Article 13. So in other words, is it only the consumer-facing service that has to comply with Article 13, or other intermediaries who are working in the back end, such as a cloud engine? Spotify is hosted by Google Cloud, for example. Do these cloud services also have to comply with that form of liability? The business-to-business cloud services comply with that form of liability, etc. Horizontal scope issues mentioned before. So for us as a company, at some point there were questions about Google Photos, about Google Drive, which is where we have a consumer-facing but also a business-facing productivity suite and Locker, where people can store and work collaboratively on documents that would fall within Article 13. You had questions about email and instant messaging, which are all partly what we call hosted products. You had people other than Google, like GitHub, like Wikimedia, and a vast range of services which are basically relying on their users uploading content, saying we have an issue with scope here, this is much broader than we thought initially, and then YouTube. Third issue, licensing user uploads. So there's a lot of talk that YouTube should take licenses and that everybody should take licenses. YouTube already takes licenses, so I don't think there's much to be gained here, at least for music. But licensing user uploads is fundamentally impossible. At least if you say that platforms are communicating to the public and are directly and immediately liable for copyright infringement by their users, you can't immunize yourself from that by systematic licensing. Why? Because no one is in a position to predict what a user is going to upload and if that includes third-party right holder content. You just can't know. Like, we have 450 hours of video uploaded every minute to YouTube. We have no idea what piece of content that might belong to a third-party right holder is going to be included in those 450 hours of video uploaded every minute. So the only way we could protect ourselves from immediate liability would be either to stop operating an open model, just making sure it's only people you know and trust and can guarantee you there is nothing from third-party rights in their uploads. Either you license all the content in the world for your platform. Now, licensing all the content in the world for your platform is difficult for at least two reasons. One, right holders have the right to say no. Like music right holders want actually to license their music on YouTube. film and Hollywood studios, for example, there's no way they want to see a full-length movie appearing on YouTube. So they will block. And second, there is no licensing infrastructure that is capable of delivering licenses in all the types of content that copyrighted material in the world, past, present, and future. If you think of architectural buildings, if you think of somebody reading from a book, that would require a license of the adaptation rights or performance rights in the book, and so forth. Final challenge, the use of content ID-like technology, so what people are calling the use of filtering technology to try and prevent the appearance of right holder protected content in user uploads. That is something that we do. At this point, I want to go back to my initial opening and the Socratic paradox. YouTube operates Content ID, which in our view is the best sort of content management software, which allows right holders to track their content in user uploads and decide whether to block it or to leave it up and make money from it. Now, Content ID does that on YouTube. It doesn't work for other types of platform. It basically only works for phonogram and video, and has developed for musical compositions. But the paradox here is we started with a problem with YouTube basically and allegedly not paying enough. And we've moved to a solution where we're saying, hey, everybody, you should all be doing what YouTube is doing, and apply Content ID-like technology across the board. So that in itself is kind of an odd twist in the reasoning. In terms of the challenges of implementing that type of technology, I'm happy to get back to it in the Q&A session. But setting aside the issues of scale, the issues of cost, the issues of engineering, and the fact that it is an arms race, there's also a big question about the governance of these technologies. Like Content ID, you know, whatever we do with the technology, it's not going to be able to resolve some fundamental issues, and it's not going to be able to give you the answer that a court should be giving as to whether an upload is infringing copyright or not. It just can't. So the real question that lawmakers sadly have not considered is, what do you do in that space? Like, if somebody is using Content ID, in an ideal policy discussion, we would be discussing not everybody should use Content ID, we should be discussing what kind of use, what kind of processes should we put in place to protect the balance of interests between users, consumer, and society at large in the use of such technology. So practically is, what do you do when somebody decides, an abusive scenario, somebody decides, I'm going to try and claim copyright in bird songs, because if I use the technology like that to make money, I'm going to be rich, and it'll take them a few days to notice, but in the meantime, I'll of course havoc. What happens when somebody claims a public domain video and it gets taken down across your services? On the basis of an honest mistake. It happened with the NASA Mars rover when a broadcaster, a news TV broadcaster, included Creative Commons footage in his Content ID fingerprint, and then it got taken down. What happens with non-exclusive rights? Because if you have non-exclusive licensees starting to use technology like Content ID, the whole thing is a mess. And with that, I guess, with these teasers for the Q&A, I will leave you here, and apologies, and thank you for giving me an extra few minutes.
Many thanks, Tobias, for your clear presentation. Although it is an interesting perspective, I believe that you managed to be very impartial